Welcome to the Insolvency and Law podcast, providing specialist insolvency and debt-related advice for business owners and individuals. For more information on debt recovery, business restructuring, and personal and corporate insolvency, visit our website www.insolvencyandlaw.co.uk or call us now on 020 7504 1300.
Hello, and welcome to the Insolvency and Law Business Advice Show, the podcast dedicated to debt recovery, credit management, and insolvency issues in England and Wales. In this episode, we'll be focusing on Director Disqualification Proceedings. Under the Company Directors Disqualification Act 1986, if you are a registered, shadow, or de facto director accused of misconduct while managing a company, you could find yourself subject to Director Disqualification Proceedings. This podcast summarizes how a company director facing disqualification can prepare themselves and protect their interests. For more information, download a free report on Director Disqualification Proceedings from the Resource Centre at insolvencyandlaw.co.uk. And you can purchase Beginner's Guide to Corporate Insolvency by Insolvency and Law Director Peter Murray. So, first of all, what are some of the circumstances that lead to disqualification proceedings? Whenever a company enters liquidation or administration, a licensed insolvency practitioner is appointed to act as the liquidator or administrator. The insolvency practitioner must send a report on the director's conduct to the government agency responsible for investigating and punishing directors who are deemed unfit to run a company. The Insolvency Service may launch an investigation if the insolvency practitioner's report includes any evidence of improper conduct, mismanagement, or deceit. Depending on the severity of the misconduct, a director who commits an act of wrongdoing while in office could face criminal prosecution and be banned from forming, marketing, and managing companies for up to 15 years. Furthermore, if you are disqualified, but continue to act as a director and be involved in companies, you will be personally liable for losses and could face criminal prosecution. So what type of misconduct is likely to lead to director disqualification proceedings? A company's creditors should never suffer a financial loss because of a director's dishonesty or bad behavior. The Insolvency Service is particularly harsh with fraudsters and directors who make preferential payments to friends, family, and other connected creditors, lose the company's accounts, trade while insolvent, avoid paying creditors by transferring assets into a new company, or fail to return deposits paid by online customers. A director who voluntarily admits misconduct can avoid court with a disqualification undertaking. In an effort to avoid unnecessary costs, the courts and Insolvency Service will consider reducing the length of a ban in exchange for a disqualification undertaking. The costs for an investigation cannot be recovered from a director whose disqualification undertaking was accepted before the commencement of court proceedings. Subsequently, to avoid court costs, many directors facing disqualification offer an undertaking at the earliest opportunity. Sadly, we're coming to the end of this episode. But don't worry, if you need more guidance and advice on director disqualification proceedings, there are 3 simple things you can do. 1. Call Insolvency and Law today on 0207 504 1300 and speak with a professional independent advisor. 2. Download a free report on director disqualification proceedings from the Resource Centre at insolvencyandlaw.co.uk. And 3. Purchase a copy of The Beginner's Guide to Corporate Insolvency, the latest book by Insolvency and Law Director Peter Murray, available from Amazon and all leading book retailers. Thanks for listening to the end of this podcast. Until next time, farewell.
Thank you for listening to the Insolvency and Law podcast. If you require additional guidance on any of the topics we covered today, visit the Resource Centre at our website, www.insolvencyandlaw.co.uk, or call us now on 020 7504 1300.